Hello, everyone, and welcome back. We are underway for our third panel of the day, and I want to start off with a very quick thank you to Dean Alexander and to the ALS and to all of you for tuning in. I've had the profound pleasure of tuning into the discussion thus far, and it's really been a magnificent conversation, including talk from a lot of election law experts in their own right. I'm hoping to continue that trend on this third panel of the day. My name is Justin Levitt. I'm a faculty member at LMU Loyola Law School, recently returned from serving as a senior policy advisor for democracy and voting rights at the White House. And I have the profound pleasure of moderating this extraordinary panel. I'm going to invite my fellow panelists to turn on the cameras if they're able to, so that I can acknowledge them and tell you a little bit about all of the ways in which these magnificent people are magnificent. Hello, Guy. Hello, Ellen. I know we're just waiting for our third panelist, Fernita Tolson, to join. So let me start with extremely truncated versions of these accomplished people's bios, because I want to get right to the conversation. So first, Guy-Uriel Charles is the Charles Ogletree Jr. Professor of Law at Harvard Law School, where he also directs the Charles Hamilton Houston Institute for Race and Justice. His bio says he's currently working on 2 books. I have the suspicion that's undercounting by 5 or 6. He has written all of the fancy things in all of the fancy places. And he doesn't just study leadership structures. He's also served as interim co-dean at Minnesota Law before moving to Duke and now most recently to Harvard. Fernita Tolson, who's just joined us, is also practicing the leadership she studies. She's now the co-dean and George and Harriet Flager Chair at the USC Gould School of Law, just down the road from me, with an appointment also in Political Science and International Relations Department. Fernita has also written all of the things in all of the fancy places. And if that's not your medium of choice, you can often find her on the TVs or on the podcast she hosts with Ned Foley at Ohio State, both of which wildly engaging. Both she and Guy have election law casebooks, and I won't pick sides by saying which one I use, but they are both wonderful resources. I will say that I've had the pleasure of testifying by Dean Tolson's side in one of her many, many appearances before Congress, and she is as calm and steady there as you will hear her here today. Our third magnificent panelist, Ellen Weintraub, is commissioner on the Federal Election Commission, and yet, wait a minute, wait, this can't be right. It says here she served on the commission since 2002. How is that possible? On a panel of deans and former deans, I'm really the only odd one out. Commissioner Weintraub may not presently be the chair, but she is unquestionably the dean of the FEC, the longest serving, and she would say, we all would agree, one of the most knowledgeable of the 6 chairs, the 6 commissioners. She's also been appearing up a storm and publishing up a storm. Most of her most meaningful publications appear in statements of reasons appended to official decisions from her current post, or sometimes, as she has recently highlighted, appended to the lack of a decision, which can be just as meaningful. Ellen came to the FEC from Perkins Coie and from the House Ethics Committee, and we are delighted this afternoon to have her and all of the rest of the panelists now with us, at least for a moment. Today's discussion, broadly speaking, kicked off with a conversation about January 6th and about racial justice and about what that means for our democracy. And then we had an equally lively conversation following about what law schools and pedagogy can do to foster democracy, also, not coincidentally, fronting January 6th and racial justice. Election law, the subject of this panel, certainly isn't the only way that law builds or undermines democracy, but it is a very important part. And I fully expect we'll talk about, again, both January 6th and racial justice, integral components of what we know as election law on this panel as well. This panel is about ways in which election law furthers and doesn't further democracy, and the democracy that we hope we will engage. It's about structures and doctrine that are taught in many of your schools. Teaching this helps empower our students to do something about it and is desperately important. I am sure that we'll discuss many of the things also touched on earlier, but I'd like to even broaden the scope, because the ways that election law fosters or falls short in delivering democracy didn't start or end with January 6th. So I now want to dive into a conversation, more of a conversation than having introductory statements. Panelists, I have questions for each of you, but I'll also be looking to you to jump in whenever you have something to add. And if you don't, I will otherwise intentionally misinterpret your facial expressions to cold call you. Members of the audience, we also welcome questions using Zoom's Q&A feature. Please do ask questions there. We'll return to them in the latter half of the panel. And I know that you all will be as engaged for this as you have been throughout the day. So let's start. I have read that Guy has described what he's doing in his course as trying to paint a picture of what type of democracy we want and law's role in facilitating that democracy. Guy aims small. Presumably, that discussion takes Guy 13 weeks, and we've only got a few minutes here. So, Franita, I'm going to put Guy's frame to you instead, because we don't have 13 weeks for this discussion. In terms of big picture constitutional structure, in the pieces of the Constitution where election law dwells, how are we doing? How is law facilitating or undermining the democracy that we want?
So we're doing terribly. But I also recognize that I say that from a place of privilege in a way, because democracy is always a work in progress. So if you look at now compared to say 100 years ago, obviously we're doing better, right? Even in the Reconstruction period, where you had African-American participation, in 80% in some areas in terms of African-American male voter turnout, we're still in a world where, it's not punctuated by violence in the way that it was. January 6th to the side, but not in a way that it was during Reconstruction. You didn't necessarily risk losing your life or your job in casting a ballot, right? So everything is relative, and I try to keep that in mind. But it doesn't change the fact that we could be much better. And part of it is, it's a couple of things. The first is that law is being used in ways to dismantle democracy. But relatedly, we're also not using the law to its full potential in protecting our democracy. So I have a book project that's currently in progress and hopefully almost done. Where I explore some of these issues. In part is, we focus so much on the Reconstruction Amendments, the 14th Amendment and the 15th Amendment. A lot that the jurisprudence around that has developed in a way where the Supreme Court has determined that there's a right to vote under the 14th Amendment, right? The Supreme Court has determined the scope of these provisions. And so because the Supreme Court has made a lot of the key decisions about what those amendments mean, the Supreme Court has also positioned itself to determine what they don't mean, or to dismantle the progress that prior iterations of the court have made with respect to trying to protect the right to vote. And so part of my project is trying to figure out ways to get around the court, but also to lay out a framework in which Congress can be in conversation with the court in some ways. So, for example, the Elections Clause is an underutilized source of constitutional authority. The Elections Clause allows Congress to make or alter state regulations that govern the times, places, and manner of federal elections. Congress has used it, for example, to pass the National Voter Registration Act, the motor voter law that significantly increased registration. But it also could be a source of authority for other pieces of federal legislation that it has not been used in that way at all. So I wrote a piece where I argued that the Elections Clause could be a source of authority for the Voting Rights Act, and that in renewing the Voting Rights Act or thinking through a new coverage formula post Shelby County, the Elections Clause coupled with the Reconstruction Amendments could be a source of authority. But that is just the tip of the iceberg, right? We don't hear a lot about the Guarantee Clause, which allows Congress to ensure that states have Republican governments. Congress doesn't really utilize its power under Article 1, Section 5 as much as it could to police congressional elections, right? So to the extent that states are adopting laws that are anti-democratic, Congress can weigh in after the fact and determine whether or not those laws have undermined our democracy in any meaningful way. So part of the problem, yes, the court has been cutting back on the protections that were in place, but we also have a constitutional structure that's being underutilized with respect to protecting the democracy that we had and laying out a foundation for the democracy that we want. So we're better, but there's work that needs to be done in the space for sure.
Fair. Well, that, at least provides some inspiration for what room there might be to improve things in the future. I know I can count on Guy to give us a sobering assessment of where we are in the present, at least. with respect to some of the things that, Fernita, you touched on moments ago, which are the role that the court has given itself, and also the Reconstruction Amendments, the Civil War Amendments, which we tend to teach a lot about in election law courses, and we tend to do a lot of work as democracy scholars about, but which the court has taken a fairly unusual approach to, as opposed to all of the other constitutional provisions, both in the original incarnation and the amendments beyond. So Guy, you've written a metric ton about this, particularly the court's approach to race and the Civil War amendments in the democracy context. Is the judicial approach that we're seeing helping or hurting?
Mm-hmm. Well, right now, the short answer is that it is hurting, and it's great to see you, Justin, as well as Ellen and Fernita. So the short answer is that it's hurting, but I think we have to place this also in context. So two things to think about in terms of context. The first is that we're trying to do in the 21st century something that we've never done before. Certainly not anywhere close to this scale. So we're trying to build a truly multicultural, multiracial democracy, and we're trying to build it within a system of which we had people who were either formally subjugated or formally excluded. So people who we believed as a country didn't have the right to participate in the democracy, whether as rulers or only as ruled. Right. And so we're trying to recreate and rebuild something, and argue, and some people would say that in the American context, we're trying to do something that very few, if any precedent for the type of multiracial, multicultural, multi-religious democracy within a historical system of subjugation, colonialism, exclusion, right? And we're doing it with a constitutional compact and framework that is relatively outdated, right? So for the most part, we have an 18th, 19th century compact, but trying to build a 21st century democracy that in many respects, right, putting together that puzzle hasn't really been done in this particular way. And the primary institution that we have for mediating our democratic disputes, especially when they fail in the political process, is essentially the court. So we have a Congress, at least currently, that is relatively sclerotic, relatively polarized. Certainly on the democracy front, we're not seeing the action that we ought to see. We are certainly divided, basic divisions over political participation. So whether voting is a right, whether it's a privilege, whether we should make it as easy for people to vote, as hard as possible, whether we ought to put the burden on the individual or whether the state ought to carry the burden, right? So all of the fundamental divisions, we have them in the political process. The best thing that we have going for us right now is our federalism system, where we can at least see some positive action in some of the states, right? So we've depended upon the court to mediate these types of disputes. And when the court has done a great job, right? So, I came to law school following a lot of the great hits. So I came to law school socialized in the reapportionment cases, Baker versus Carr, Reynolds versus Sims, and some of the right to vote cases like Harper, right? Where we had this vision of the Supreme Court as guardian of democracy. And for those who are in law school or socialized with law, remember John Hart Ely's Democracy and Distrust, providing a justification for the court's supposedly anti-democratic role, and one justification of it, or two justifications, is sort of the role that the court plays in policing the boundaries of the democratic process and protecting racial minorities who have been formerly subjugated and whose powers in the democratic process are really or not sufficiently strong to protect themselves, right? So two particular elements, race and voting rights, and law and democracy as serving as two justifications for judicial review. And for the most part, that was the dominant view and understanding, right? And then you get to sort of, you end up with cases like, especially the most recently, Shelby County, Bronovich versus the DNC, Citizens United, McCutcheon, Rucho, right? And not to, and we can't forget like Shaw versus Reno and Miller versus Johnson, right? So you're seeing a series of cases in which the court seems to be abdicating its role and either protecting democracy, right? Buckley versus Vallejo is another great hit, right? Either protecting democracy or abandoning the role of protecting racial minorities. And of course, we're waiting with bated breath, Moore versus Harper and Merrill versus Milligan. Again, two cases, one about more broadly law and democracy, and the other is about the role of race. So we're seeing a court that seems to have abandoned its role. And then in Rucho versus Common Cause, I mean, you could take that as literal abandonment, and even in Shelby County, with the court based in Rucho versus Common Cause, with the court saying, hey, we have no role to play, it's you all fight it out. And arguably in Shelby County, with the court saying, okay, racial minorities no longer need that type of protection, right? So currently we have a court that is at best one that is sitting on the sidelines, and some would argue much more aggressive than that, a court that is anti-democratic in particular ways. So our fundamental theory and about the role of the court as an institution that is supposed to protect democracy and protect racial minorities in the democratic process is one that absolutely need to be revisited, because we're not seeing the court playing that type of a role, at least not in this moment, and arguably not even in this century.
So I couldn't help but notice Ellen's eyes shoot up at the mention of Buckley, not to mention McCutcheon at all. I want to get to those cases in just a moment, but before I do, I want to offer and I know this is a friendly amendment, an amendment to the notion that the court is abandoning or sitting back, and certainly in some areas that is abundantly true. But I can't help but notice that in some places where we think federalism is particularly important, and I think you're right, that is in these moments something of a gift, the court is actively reaching out to shut federalism down. I'm thinking here of two particular ways in which the court has seemed to be aggressively not only abandoning its own role, but forcing others to abandon their role in the protections you mentioned, Dean. One, the Purcell Doctrine, the notion that you can't get relief for election-related wrongs if you're too close to an election. And the Supreme Court has only issued opinions on this, under this doctrine, in effectively the shadow docket. So without full briefing, without full explanation, without really laying clear what the stakes are. And when it's too close to an election, has continued to move back and back and back and back and back in time, so that nobody really knows whether the beginning of an election cycle is too close to the end of an election cycle to secure relief in the coming election. And that's an imposition on federalism in the sense that it shuts down lower federal courts from at least chilling and sometimes directly shutting down without explanation, lower federal courts from providing relief when, at least some of the judges farther back in the system, chosen or approved by home state senators, very in touch with local electoral procedures, aren't able to weigh in when they spot problems in a way that actually delivers results in the pending election. The other one I just want to call out really briefly is Moore, the pending independent state legislature theory case, which takes 2/3 of the local part of federalism out of federalism. If the court decides to buy this theory that state legislatures are freed from state courts and constitutions, and potentially at the extreme level, even governors, in regulating congressional elections, that's really a very particularized version of what federalism means, privileging one set of actors that's now free to gerrymander themselves as much as they want over all others in a way that doesn't, it demonstrates a rather profoundly weird respect for states as entities in raising one particular entity up above all others. I wondered if any of you had reactions to that, and if not, then I'll clear the way for Ellen's eyebrows and talk about the way the court has reacted to campaign finance in the recent past.
So I do think that it's interesting how, particularly in my work, I often think about the elections clause as a tool that can be used to further democracy. And I think the independent state legislature theory forces us to contend with the ways in which that language can be used as an anti-democratic weapon in a way that I think is contrary to how we think about Republican government in this country. So much of Republican government, especially after the 12th Amendment, where the country was faced with essentially a tied presidential election and the prospect of having a president that was not the popular choice, Republican government really has centered on this notion of majoritarian sentiment that the independent state legislature theory kind of runs counter to, because what it does is it frees the state legislature of any accountability to the people that put them there. And it also frees them of the document that actually created them, right? And it's really the closest expression of the people's preferences that you can get, the state constitution. So in many ways, the theory is not only problematic just in the sense that it's a problem for democracy, it also runs counter to our sense of what Republican government is, right? Republican government is distinct from democracy in some ways, right? Republicanism, I look at it as a broader umbrella, right? It could be consistent with democracy, but it can encompass other forms of government. But I do think the core of Republican theory is that there must be some way of reflecting majoritarian sentiment, and that this theory, let me be clear, not doctrine, this theory runs counter to our sense of what government is supposed to do in the 2 centuries since the 12th Amendment.
Yeah, I mean,
Sorry, go ahead, Keith.
Yeah, and part of what's interesting about this is we see the court be willing to accept novel theories, whether it's in Shelby County, whether it's here and more. We'll see what happens. But also in the Bronovich case, right? Sort of like, now Section 2, the disparate impact aspect of Section 2 of the Voting Rights Act means something differently because of sort of these methods of statutory interpretation, these elements that no one knew or anticipated, that where these are judicial doctrines that are essentially made up. So so part of the role of the court here and creative constitutional interpretation or creative statutory interpretation as a way of undermining the development of democracy, I think is something to account for.
Can I add one other thing, because Guy's point made me think of the fact that I think this is why it's important to have these dialogues between the branches, right? Because the court, in the sense of, by being able to bless this particular theory, it really does, to the extent that we questioned it before, it really does put them in a position of being kingmaker, right? Because they are essentially anointing the state legislatures with this power to disregard all other branches to the detriment of the people that they are supposed to be serving. And it's so interesting when you think about the fact that the court has been so aggressive about trying to get out of the political space, right? Trying to get out of it, Rucho, right? The decision that they don't even want to deal with partisan gerrymandering claims, yet they have positioned themselves to determine that they're going to give the most self-interested branch the authority to gerrymander themselves, until tomorrow, right? It just seems odd to me that we find ourselves in this position. It really shows how things have become so distorted and messed up with how the judiciary is currently working.
So I can't think of a better segue to bring Ellen into the conversation, because when it comes to branches listening to each other or the court deciding to elevate itself over others, the realm of campaign finance and campaign law is top of mind always. This is a court that seems to think of itself, I think, or projects the image of itself as exceedingly protective of speech. And in that vein, I don't know, Ellen, whether you have any opinions at all on the ways in which the court's views on campaigns and campaign finance are either helping or hurting democracy in protecting the speech that they're protecting.
Do I have any opinions? Well, let me think about that, Justin. First of all, let me thank all of you and Dean Alexander for putting up with me on this panel as the lone non-scholar. I feel very honored to be in this illustrious company. I haven't written any books at all. The court, the court claims to be protective of speech, but of course, in my realm, what I see is that it's very protective of money. And money, I would argue, is not the same thing as speech. And if you talk about the impact on democracy, I think one of the fundamental principles of democracy is that everyone's voice should be equal and everyone's voice should be heard. So if you have a system where there are some people who are in a position to give millions and millions of dollars in order to get their voice in a very prominent position that to promote their views. And, the rest of us, maybe we can give our $25 contributions, and there are a lot of small donors out there giving those $25 contributions, but none of them are going to have the impact of one really wealthy guy, and it is usually a guy, it's usually an old white guy, if you look at the list of big donors. Those people have inordinate interest and they can get their phone calls returned. On the Hill, they're supposedly keep all of their political operations separately from their official operations, but they know who the big donors are, and those guys get their phone calls returned pretty much every single time, and often on both sides of the aisle. Even if they're only giving to one side, they still pose a pretty strong threat to people on the other side that, I could spend big in your election, you've seen me do this before, if I don't get the kind of policies that I want. And the court is just extremely solicitous of the right of people to spend as much money as they want, and they seem to live in this fantasy world where, well, everybody just gets to spend as much as they want. Well, no, everybody doesn't, because everybody doesn't have that kind of money. In the Watergate scandal, which led to the creation of my agency, we were talking about a scandal involving about $1 million, and it riveted the nation, and people were scandalized and shocked by that 50 years ago. Well, in the 2022 election, the top 100 donors each gave more than $3 million. And okay, so there's been some inflation. $1 million in 72 is probably worth about $7 million now. That would only be the top 41 donors in 2022 who gave more than $7 million. More than $7 million. They're not giving that out of the goodness of their heart. They're giving it because they're trying to accomplish something. They've got an agenda. It is often not the kind of transactional corruption that people talk about, where somebody is trying to achieve, a particular tax benefit that's going to benefit them or some benefit for their particular industry, so much as a lot of these big donors are ideological donors, and they have a vision of America that they are trying to impose on the rest of us. And it is not necessarily the vision of most working class people. And there's also the problem of the way our system is set up, where everybody has to spend so much time trying to raise money. All the politicians do. They spend hours and hours every day. And who do they call? They call the big donors. They're not calling the $25 donors. They're calling people who can max out. And so they have a conversation with those people. They don't just call up and say, give me money and hang up the phone. They're in conversations all day long with people who are in a position to max out. And so what they're hearing about all day long are the concerns of the very wealthiest members of our society. And again, those concerns may not be reflective of the concerns of working class people, because those folks, they're not worried about how they're going to pay for their kids' college educations, or what happens if they have a medical emergency, or how they're going to put food on the table. Those just aren't their concerns at all. And it takes, I think, a very strong will and really people with the best intentions to kind of put all that to the side and say, oh, that's right, I did spend 5 hours today listening to all that stuff, but that's not really what I ought to be paying attention to. Citizens United has kind of captured the imagination in a way that a lot of these other cases that we're talking about, which are equally, if not more important, really haven't, because I think people understand money. This kind of resonates with people when you say this guy can give millions of dollars and, go ahead and compete with them if you can. That makes sense to people as a corruption of the process. And it's extraordinarily unpopular. And I think it is one of the reasons why the Supreme Court's credibility has declined, because I think they are really out of step with how most people in America think about corruption. They have really narrowed in the definition of corruption. There's all this language and several opinions about leveling the playing field, being antithetical to the First Amendment. Heavens, we wouldn't want everybody on a level playing field. What other what other enterprise do we have where we say we don't want a level playing field? They just seem to live in their own world, which, as I said, is not reflective of the way I think most people's values work and how most people would like to see campaigns financed, or how they would like to see their elected representatives engaged in how they fund their campaigns and who they're listening to all day long. And I think it is part of why, one of many reasons why the Supreme Court's reputation has been on the decline, because they're just out of step.
So I will just take a moment. I'm going to come back to that. Just take a moment to remind people that we have the Q&A function on Zoom, and your operators are standing by. I would love it if you have questions. We will certainly have a broad-ranging discussion, but encourage you to make yourselves known. Ellen, you just spoke to the ways in which court decisions can impact the views of Americans on whether the system's fair or not, right? The perceptions of fairness. And certainly, now I am going to bring this back to January 6th. One can argue that January 6th was fostered by a view among some, actively cultivated, by a bunch of fairly cynical folks seeking either power or money or both, that the election systems as a whole were unfair. To what extent, is a question for everybody, to what extent do you think that the structures of election law have actively furthered the notion, correct or incorrect, that the elections are unfair, that they're not actually capturing what the American people want to see in their elected leadership in ways that, at the end of the day, can boil over in frustration, again, to calculated, directed frustration. I don't want to pretend that anything about January 6th was organic, but can boil over into frustration at the way the political system is working, even if it doesn't erupt into violence.
It makes me think of the extent to which the baseline in this country, that fundamentally we are a country that was founded on a culture of minority rule, right? In some ways, January 6th is a rebellion against change, right? Because the fact of the matter is that Donald Trump won the presidential election in 2016, but he won the presidential election in a way that he was not a preference of the majority. But the system is structured where that is an outcome that can happen, right? But to what extent do we internalize the sense that, yeah, we may not have the numbers, but we can still have our preferred policies. We can still, have the system that works for only a few and not everybody, right? To some extent, if you listen to the comments that have been made today, the one connecting thread is the fact that we have a Supreme Court that can push minority viewpoints, in part because the system allows it. And perhaps that comes back to Guy's point about the fact that we're trying to make an 18th, 19th century do 21st century things, right? Be a 21st century system of inclusion when we're still working within a framework that's really designed to promote minority preferences. And so, yeah, when you disrupt that system, it's not surprising that we end up with a January 6th that looks a lot like the violence that we saw in the 19th century, right? Because in some ways we have created a culture of minority rule. So that's the first thing. The second thing is white people don't like to be told no, right? So I do think that on some level that, what happened on January 6th and what we're seeing today is demographic change, right? We can talk about it in terms of demographic change. Demographic change, when you have a country that was for over 2 centuries ruled predominantly by white people, and now you have Black and brown people coming in and telling them no, there's going to be a backlash, right? And then you have to tie that in with the fact that we do have a culture of minority rule, right? Before it was privileged white men, right, who owned property. We expanded that category of white men. And then for much of the 20th century, it was still white people. And now we have Black and brown people who are essentially coming in and telling them no. And we're getting 18th and 19th century responses, right? So that begs the question of whether or not, do we need to rethink fundamentally how this country works and who we want to be? Or are we too wed with the idea of being one of the oldest democracies in the world, such that we have to stick with this constitution that may not be equipped to be the 21st century democracy that we needed to create?
Yeah, I mean, to build on that, I mean, sort of think about the fact from the presidential system, people only have a right to vote for president within their states and only by the privilege of their states. Right. So we have sort of like an electoral college shadow framework built upon an expectation of a national election, but we don't have a national election. But we also fully don't have a pure electoral college system either. We don't have a federal agency that runs the federal presidential election. We don't have a federal agency that says, here are the results, here are the things that happened, right? So we're reliant upon, ABC, NBC, Fox News, it's CNN to tell us, oh, this is, this presidential candidate actually won this particular state at whatever time they believe that they can make a call based upon their statistical models and actual election returns. So we have a system and design that is ripe for misinformation and disinformation. So when you combine that with what Fernita is saying in terms of, look, there's an expectation of who is entitled to wield political power in this country. There's an expectation of how that power is going to be wielded. But then there is a mechanism that permits disinformation and misinformation because there is no authoritative framework that one can go to. And even though we have some distrust of federal agencies, as a person, Justin, who've worked in many different domains, you know this better than I do, right? So even though there's a distrust, but nevertheless, there's a they perform a particular function, but we don't even have that. So then it's possible for someone to come in and to say, well, look, there is fraud. I actually won. Your votes weren't counted. And people who believe themselves to be subjugated are ripe to believe in that misinformation and disinformation. And some of them are going to listen to calls to take back political power and to take back their country, right? So I think we can look at the court, but we also have to look at our foundational constitution and our mechanism. And at some point, we have to think about how do we modernize the process and structure of our democracy to be responsive to the 21st century demand that we're putting on it.
So a very quick reaction and then a question right back on that last point. Yes, having just come from a part of the federal government that very explicitly and very thankfully does not have a direct role in running elections, I am overjoyed that there isn't one central authority that can just flip a switch and decide that an election either happens or doesn't happen or how it happens. But you're absolutely right that the very decentralized nature, the excessively decentralized nature of the elections that we do have creates a lot of room for distrust and for misinformation and for disparate practices, which may be fine locally, but people see with suspicion when practices elsewhere don't mirror the practices that they're used to. The question, so coming back to the role of the law in these features of democracy, we have a very protective First Amendment, far more than other countries. Other countries have regulated the campaign finance environment far more than we do. But the same instinct that causes the deregulatory impulse of the Supreme Court here has also created a far more robust protection for individuals, even when they are fostering misinformation or disinformation. We have a thumb on the scale against regulation. We have a right to lie proclaimed by the Supreme Court. We have a Congress that has passed Section 230, which built the internet, but also insulates now our largest scale publishers for practical purposes, even if they will dispute that label legally, from any liability for their role in fostering or promoting disinformation, as long as they are platforms. We have a libel standard which protects a huge amount of virtuous publications, but also a small number of non-virtuous publications. So to what degree do you think that First Amendment law in the country is aiding or undermining our attempts to hold on to the democracy we have? And I guess part B, is it impossible, is it too much to ask of the law to be able to foster the trust that we need? Do we need that trust to come from a different source? Yeah, Ellen.
I think the undermining of trust in our system is one of the huge problems that we've seen in democracy, because it can't function without trust. I was many years ago, I had a group of people from Developing Democracy, and State Department brings these people through on these tours. I'm sure you've talked to some of them, Justin, to try and learn about how our system is structured. And I was asked, maybe in the, early 2000s, why do people trust the results? Why do people accept that the announcement of who won and who lost? Because in my country, if your side lost, people wouldn't accept that. And when I was asked that, 15 years ago, I was dumbfounded by the question. I was speechless, because it had never occurred to me that people would not trust the outcome of the election, that people would not trust when people said, this is the guy who won, that was the result. And I said, well, we've got hundreds of years of running elections. We've got all these professionals who do it at the state and local level, and you go in to vote, and often it's your neighbor sitting there taking your name down and checking your ID in places where they check IDs. But I really didn't have a good answer for them then, and I really don't have a good answer today when it has become such a pressing question. I do think that, we talk about disinformation. One very hot topic right now is AI. I mean, you and I think were on a panel a few years ago when we were talking about deep fakes and how, we got to do something about these deep fakes. Well, the future is now. And we really have to do something about the possibility of AIs coming along, and particularly with public figures for whom there's a great public database of what their voice sounds like and what they look like. It's really easy particularly for famous people to have these fake videos out there about them. And we have got to, at a minimum, get some kind of disclosure of a requirement when there is manipulated media. And, this was, as I said, a topic we talked about sort of as if, we're going to have to do this a few years ago, but now it's become very pressing. Not that that will solve the problem entirely, but it is something that would be constitutional.
So let me commend, we have one question so far. I'm hoping it's joined by others in the Q&A. That's just a reminder. Franita, did I see you come off mute to respond? Ellen, please.
Yeah, no, I just wanted to hop in and just make the point that I don't think the judiciary really internalizes the harm of its decisions, right? I think that it's formalistic in a way that they can kind of decide things and then kind of leave it out there. And that's the approach that they've taken with the First Amendment. Is there's an idealism to it, right? Like the idea that this marketplace will filter out good and bad, and that there's no really harm that can come just from leaving the market unregulated. This is why there are so many comparisons between what's happening now and Lochner. Really, we're living in this moment where it's the Democratic equivalent of yelling fire in a theater, right? But the court is ignoring the facts on the ground in favor of being just incredibly formalistic in a way that allows it to claim that it's just following the law, even though they're ignoring the people who are harmed by the decisions that they're issuing. And so I think that's the problem. Having the court involved would require the court to acknowledge what's going on the ground. I think that's one of the huge differences between what happened in the 1960s and what was going on in the 1870s and 1880s, right? In the 1870s and 1880s, you very much had a Supreme Court that's looking at the Reconstruction Amendments and ignoring that Black people are being killed daily trying to exercise the right to vote and trying to exercise the rights that were promised to them, right? And so we have something very similar today, just in the sense of the court ignoring the fact that there are harms that come from taking this very formalistic approach to interpreting the Constitution. Whereas in contrast, the 1960s was very much a moment in which the Supreme Court was like, okay, we're going to give Congress room to do these things because the South in the last 70 or 80 years has proven that they are not a reliable partner when it comes to building a democratic society, right? So in order for democracy to work under the Constitution that we have now, it would require some realization that there has to be that flexibility in order to take into consideration the fact that people are struggling to exercise the rights that are promised to them, that we think of the court as being tasked with protecting, But instead of doing that, the court is allowing things to kind of run amok in the name of formalism.
Let me ask a follow-up on that, and then I want to come back to something that Ellen said a moment ago. To follow up directly on that, so you're advocating, I agree, for the court to leave room for policymakers to not make policy and to actually help us get out of this mess. Sometimes that policies can be self-interested, of course, is a problem that we confront in election law all the time. A particularly notable example of that is the Section 5 of the 14th Amendment, which gives Congress the right and the power, just like it has the right and the power to regulate commerce, to regulate the ways in which equal protection is delivered to the public and the ways in which due process is delivered to the public. And Section 2 of the 15th Amendment, which gives Congress the right, just like its right to regulate commerce, to regulate the ways in which racial equity is delivered to the public and the ways in which discrimination is contested. Shelby County, we're now almost exactly 10 years to the anniversary of Shelby County, with a continuing Supreme Court cases on the Voting Rights Act in the near rearview mirror, and a few very much looking through the windshield coming down the pike. Again, you've written tremendously on this. To what extent can we escape? To what extent is there room to escape within or outside of the federal courts, within or outside of the congressional structure that exists at the moment, the Supreme Court's constraints on what Congress can do, and not only can do, but has done in the Voting Rights Act?
Yeah. I'm sorry, Guy. I don't know. You can go.
Oh, no. You can go first if you like. No problem.
No.
Go ahead. I'll
Actually, no, okay, I'll go, but I will point out that Guy's going to make the better point, because I was going to make a Beyonce and Destiny's Child reference, because really I think about the court as Beyonce and Congress as Destiny's Child, and she's pushing them out, right? Because if you I think if you look at Section 5 of the 14th Amendment and the court's power to determine what Section 1 of the 14th Amendment means, even in the context of allowing Congress to have room to weigh in on constitutional interpretation, the court has even limited their ability to do that, right? That's the City of Bernese case. So it's like, even when Congress is exercising power pursuant to constitutional text that empowers it, the court still feels like it has the authority to say, Congress, no, stop, right? This goes back to my earlier point about the partnership. The partnership is really important. I am not saying that Congress, instead of having the court do these things, we should just automatically pivot to Congress. My point is, this is about the partnership. This is about the branches being in constitutional dialogue. One way to push back against that and Congress to be more assertive about staking out its sort of space in this debate is for Congress to act more pursuant to powers where the court feels like it doesn't have a say. So if Congress is doing things to protect our democracy through the guarantee clause, the court has already said that that's a non-justiciable political question, right? But that is space for Congress to stake a claim that was essentially denied to it pursuant to Section 5 of the 14th Amendment, right? So I just think that, there's room here for both, but it would require Congress to be more aggressive in taking back the power that it has abdicated to the court.
So one disagreement with Dean Tolson and one piece of agreement. The disagreement is that she definitely made the better point about Destiny Child and Beyonce. I will still take time to get my mind around that. There's just no doubt that you went there. Nothing I can come up with could ever top that. The point of agreement there is, so both on the partnership parts, right? So double-sided agreement. On the partnership part, as well as on there are areas in which Congress can act. I think what this tells us, though, is that we don't just have a court problem. We have a democracy problem, right? It's pretty easy for us to focus on the court, and particularly where at least the political scientists would argue that this current court is out of step with where the country is. But it's not a court problem. Congress could have acted And there are bases upon which Congress acts. So it's true that the court has limited, as Professor Tolson has said, Dean Tolson has said, Congress has limited, but there are also other areas that, as she's pointed out, that Congress could have acted, and we don't see Congress acting. We see the same things happening at the state level, both with state courts as well as with state legislatures, right? So we have a democracy problem. We're trying to figure out as a whole country in this moment, how committed are we to the democratic exercise? And to some extent, that's a partisan question, but not totally a partisan question, because even the Democratic Party is still figuring out. You look at this like New York State as an example, and you wouldn't point them out as sort of like the paragon of democratic participation or the way that democracy laws ought to be made, right? So we have a democracy problem in this country. There are institutions in which, and places in which it is worse than others. We used to think that, hey, we had a race and democracy problem, and it was a Southern problem. But I think we're recognizing that as we're trying to move into the midpoint of the 21st century and trying to really think of ourselves as the world's leading democracy, that we actually have a democracy problem, and that we need to figure out how much do we care about these fundamental democratic principles, like equal participation, as an example, as Commissioner Weintraub pointed out, right? How much do we care about these fundamental principles, right? And so once we figure that out, then I think we will see, we will see things fall into place. But until we do, we will see the manifestation, whether it's at the Supreme Court or the gridlock that we see on the democracy question in Congress, or at the state level or the state Supreme Court level, right? We're seeing it across all geographies and institutions within our country.
So for the attended, for those who are attending today's talk, I'm sure there are law review advisors among you, and I fully expect to see a raft of student notes or student note suggestions on Destiny's Child and the Supreme Court, probably in either full titles or subtitles coming in the near future. Keith, to your point about the democracy problem, one of the questions that, oh, sorry, Ellen, please.
I want to interrupt to say that I think comparing this Supreme Court to Beyonce has got to be the nicest thing that anybody has ever said about this court.
Flattery is the way to get what you want, Ellen. And you're looking lovely. The democracy problem that we have actually feeds directly into one of the questions that we've gotten, and again, fully welcome in the Q&A, any questions you might have. It's been a pretty wide-ranging discussion so far, and I feel that we are up to the task. We're equipped to answer whatever questions you've got. This one's a good one about the democracy problem that we have. What does it mean that a majority of Republican members of Congress, after experiencing the insurrection and the breach of the Capitol on January 6th, voted not to certify Biden's election? And I'll add, not only what does it mean, but how do we confront that? Because that, I think, does reflect the deep democracy problem that Guy is talking about in one of the institutions that, ostensibly is the home of the people's house.
I think that I think about the question a little bit differently. So for me, the question is what happened in Congress after members of Congress witnessed the insurrection, many of whom were running for their lives, and they still voted not to certify the election results? Is that consistent with the system we have now? And how do we feel about that? Right? So we can criticize them. We can have a problem with it, but most of those people went on to be reelected to office, right? So we have to ask ourselves the hard question of, is this the system we want to live under? And I don't know the answer to that. I mean, I think it's highly problematic, but the reality of the situation is that we live under a system that allows anti-democratic results. We hold ourselves out to the world as a democratic society, and we are doing a terrible job of addressing that disconnect. And I think what happened on January 6th is just a reflection of that disconnect. And it goes back to Professor Charles's point that we just have a democracy problem, right? And we are not engaging with that problem. And, you know, this is honestly a weakness that some of my work suffers from, right? Because I'm still sort of operating in this framework of like, how can we squeeze democratic juice out of this anti-democratic document that we have, right? Like, fundamentally, I think January 6th taught us that that tactic can only go so far, because we live in a system that allows anti-democratic results, and it allows individuals who do anti-democratic things to go on and enjoy long careers. And that's a problem.
And another way to put the question may be, to what extent does the law need to protect at least some space for anti-democratic views if it purports to be a pluralist system? Or are some views or actions simply off of the table, and who gets to decide which ones those are? You know, taking expression off of the table has often been predicate for abuse of that very power in the past. And so there's good reasons to think that the system should remain as open as it is to views, and hope that the people have the good sense to reject those they don't want to live under. And sometimes that hope we can be disappointed by the outcomes.
Waiting to see. Ellen, are you going to jump in? I'm happy to wait for you. Okay. So I mean, I think there are two things that I'll say very quickly. One is our system, we're not very good about talking about the problem of partisan asymmetry and polarization in this particular context, right? I mean, it does and ought to make us a little bit uncomfortable to say that, it might be the case that one of our major political parties, or at least a significant segment, people from that party are less committed, that segment is less committed to the democratic enterprise than they ought to be, right? That should make us uncomfortable, because we need the political legitimacy of both parties. But also there's a reality that we have to confront that is, that is a very hard one to confront. And I think we have to figure out how to think and talk about that in a way that furthers the democratic enterprise, that doesn't undermine the democratic enterprise. All right, the second thing is that there's also another institutional weakness, and that's the problem of populism. And though we live in a world of partisanship and polarization, but of weak parties, right? So we're so worried about the strong, in this case, I would say strong man, right? We're so worried about the strong man effect and the populist appeal, right? And so these are the reasons why folks are reluctant to criticize, certain individuals, because they're worried about losing political power and the populist appeal of that. So I think we need stronger parties. Because the counter, the effect is we can either have strong people or strong parties. And as between the two, I think I'd rather have strong parties. So that way, at the very least, there's a chance, especially if we're going to have two political parties, that we can have two political parties that are committed to the democratic enterprise. Because right now we're chasing people, right? It's about, especially at the presidential level, certainly at the presidential level, but not just at the presidential level. It's so much more about who the individual is as opposed to the institutions. And that, I think, it's undermining any ability for, it's undermining our accountability mechanism. And that, I think, is a significant problem, and sort of leads to this partisan asymmetry that we have a hard time facing up to, talking about, and addressing.
I think, Ellen, you were going to, please.
Yeah, I'll just throw in that I think, this is a bigger problem than election law. That's probably an obvious point, but there are a lot of things that feed into this increasing lack of trust of people basically not being willing to accept results that they don't like. It has a lot to do with the media. It has to do with the splintering of the media, with the severe diminution of local reporting, which is making it harder to hold local, state and local officials accountable, with the way the algorithms work on social media, so that, you start off, looking at something that you think is kind of interesting and maybe a little edgy, and before you know it, you're being directed to articles and videos that are full-on conspiracy theories. And I think that is one of the reasons why there's a lot of interest in Congress in making another stab at Section 230, and is there some way to address the algorithms, not the content, but the way the content is promoted, because I think that also is having a deleterious effect on our democracy and on our faith and our ability to function. When I talk to students, and by the way, since I'm talking to a bunch of law professors, I'll put in a plug that I'd love to talk to students. So invite me to come and talk to your class. I've talked to Guy's class. I always encourage them to get involved, to obviously to vote, but also to get involved in trying to make their voices heard in their local communities, as well as, at the state, national, international level. There's so many opportunities, particularly for law students, to do good in the world. And when we talk about elections, sometimes students who live in very gerrymandered districts, they say, well, why should I vote? Why, my vote doesn't really matter. And I think one has to constantly push back against the notion that that people should just sit it out. If you don't think your vote matters in this election, well, vote, but then also advocate for better rules and laws that will help your vote have more meaning. There's always another way of getting at the problem. One thing I've been troubled by recently is seeing laws like the one that was just passed in Texas, where the state government is assuming the right to take over the election from the local jurisdiction that just happens to be the most populous jurisdiction, that just happens to have the largest minority population, and only that jurisdiction in Harris County. The Secretary of State now has the right to go in there and rerun the election if he decides that it didn't look right to him, and that again, I think is an anti-democratic movement that we're seeing. So one example of state governments that are trying to intervene in local areas that have some local control that represent the local population, but maybe is not the same population that elected the state government statewide.
And what you're pointing out is 8 or 9 or 10 of the different ways in which election law inevitably isn't just election law. I think many of the faculty members here from different schools have different versions of courses that touch on democracy and the election system. Some of them are called election law, and the scope of those courses may be radically different, because things like home rule, things like state and local government law, things like media law, things like First Amendment, even away from the First Amendment protections for the right to vote, are critically important to understanding the scope of the democracy. And things like statutes and regulations course, leg reg courses, critically important to understanding how we get into or out of this mess in the first place. And all of that is really, it's not within election law, and yet it very much is within election law, because it all contributes to how it is we come by the information and the structures we need to figure out who to vote for in order to cast votes that are counted. One thing that both Guy-Uriel and you have both mentioned now is the way that, or at least it occurs to me that the way that parties are structured is responsible for some of the condition in which we find ourselves. Obviously not contemplated, or at least purportedly not contemplated at the get-go in the original constitutional structure, but part of it from the very beginning. You mentioned that, between strong men and strong parties, you'd rather have strong parties. And then said, and if we're going to have two, and I guess I want to ask, right now, election law is very oriented to having two. And is that part of the problem? The Supreme Court has issued a number of opinions, essentially enshrining two parties into the constitutional system in a way that is, at best, uneasily related to the original design and in some ways directly antithetical. They have construed Federalist 10, for example, repeatedly to mean exactly the opposite of what it means in warning against factionalism, by building up two extremely strong national factions that pervade into state and local government in ways that several scholars have emphasized makes absolutely no sense. For local races to be run as if they're the same policy pronouncements for national security or national, economic stakes for national races. The party platform of the president or of the U.S. Senate doesn't need to be the party platform of the city council. Right. And having them all operating under the same party line doesn't make a lot of sense in a lot of reasons. But the election law that we have inevitably channels all of our conflicts into those two main structures. Is that part of the problem?
Yeah, I think that is absolutely part of the problem, and I think you've articulated it like extremely well. Our court and our judicial system, unfortunately, I think, has a very bad theory of democracy, especially lately. But in some respects, sort of the two-party, the preservation of what some have called the two-party duopoly, right, sort of goes back many years and is not even an effect of this modern Supreme Court, right? Sort of like this understanding that we need to privilege like these two particular parties, and also we have a bias against proportionality at the same time. So we don't have a system that is actually truly reflective of the ideological and partisan preferences of the electorate. And I think, again, that's a court problem, but that's also a Congress problem too. So, and I think the results of that are exactly, sort of we've flattened the relationship between state and local and federal. So now everything is nationalized. There is not this understanding that there could be regional variation, right? So everything is nationalized, and we see the effects. Judicial races at the state level, as well as local races, are given these extremely national implications, because sort of the national conception of partisanship is what controls and what dominates. And so again, moving into a modern framework, we have to confront this idea that, hey, maybe we can have more than two parties. For many people, that's anti-American to think in this way. Maybe we can have proportionality. Again, for me, as I tell my students, and my guess is that you all tell your students a version of this, that if you ever want to make the Supreme Court mad, just use the P word, right? The proportionality word. And across many domains in election law, like the court singles out proportionality as essentially anti-democratic and anti-American is one way of looking at it. And I think we're going to have to confront those things and address them, because they too are part of the problem of democracy as we're experiencing it, because we can't have the representation and the accountability without changing that aspect of our system.
I'm always surprised by our forgetfulness and our lack of imagination, right? Like, it's not as if there weren't third parties, right? But I think he is right that if someone seriously put forward this idea that we should be a multi-party system, or that there should be parties that could effectively compete, we shouldn't have a system where the rules are stacked against third parties. I think for some people it would feel anti-American. And it's weird to me, because there were times in which third parties were viable in this country. And I think part of it is tied to our lack of imagination. So not only have we forgotten the past, we also can't see past the moment that we're in, and we can't dream bigger in order to get to where we need to be in order to truly be a functioning democracy. Part of that is also assuming that America is forever, right? Like, to what extent have we really grappled with the idea that if we don't fix these problems, this country might be on its way out as the democracy that the number one democracy that we hold ourselves out to the world, right? This democracy is something that you have to fight for. It's a work in progress, and it takes both imagination, and it also takes learning from the lessons of the past. And so I really liked your sort of intro to this portion of our conversation, because I think it highlighted, right, the fact that it reminds people that we can be more than what we are. I think in some ways we've forgotten, and I hate to like ask bring in what is the meaning of life comments, but I really do think a lot of the conversation today really highlights the fact that one of the reasons why we find ourselves in the mess that we are in currently is because we have forgotten how to fight for the very thing that we claim to be defending.
A republic, if you can keep it. And that's an instruction to each and every one of us, including those of us who were not there. Joe Biden likes to talk about his presence at the founding, but it's well beyond that. That's a mandate. And you're absolutely right. We got to fight for it if we want it. And there are lots of different ways in which that fight's happening. We are closing in on the end of our time. And so having gone through 85 some minutes of all of the ways in which election law seems to undermine our views of democracy, which is exactly where I thought we'd be at 85 minutes in. I'm going to ask to bring us out on an uplifting note, if you can manage to find one, about the ways in which we are making progress. And I will point out two things just to give you a moment to think about what that might be, and then we'll go speed round. I'll point out two very quick things, and that is if you chart out the percentage of the American adult citizenry that has voted since the beginning of the Republic until now, that graph goes in one unambiguous direction, up and to the right. And that is unquestionably progress. And it's a forward momentum worth of progress that we have shown a devotion to continuing. It's not that there haven't been steps back or to the side or way back in evaluating that progress, but still the graph's going in the right direction, even if we have an awfully long way to go before it is as meaningful as we'd all like it to be. It bottoms out at about a C- in terms of percentage of the eligible electorate. And for faculty members, C- leaves a lot of room for improvement, but we've been improving steadily over time, even if not linearly over time. The second piece of progress is really recent, and that is one major potential imposition to democracy continuing its run, as Pernita reminds us, in America, is the way that electoral votes were counted in Congress. And just recently, we had a bipartisan bill pass to reform in fairly significant ways the ways that the electoral count actually proceeds. Clarifying some things that had been ambiguous, clarifying some things that hadn't been ambiguous, but really wiping out any potential room for ambiguity whatsoever. Not all ambiguity. I give the final bill that passed probably a B, but in these times, a bipartisan B is pretty good. And it did take a lot of nonsense off of the table. So there is room, there is opportunity for even bipartisan agreement on fixing the things that might really be, that might really sink the ship when we're all focused on it. And so I'll offer that as my one uplifting piece. Now we've got three others still to come in 5 minutes.
All right, I'm gonna jump in on a similar note that in 2014 we had the lowest electoral turnout in 70 years. You had to go back to World War II when a bunch of the electorate was overseas fighting for democracy to get such a low turnout. And a lot of people don't think midterms are important, but I will remind people that in that 2014, in that really low turnout election, control of the Senate changed hands. And that is why when Barack Obama nominated Merrick Garland to the Supreme Court, Mitch McConnell was in a position to say, no, we're not going to have that vote. Now, I don't want to be partisan about this. It's not, I'm not saying that, you might think that's a great result and you might think that was a terrible result, but it was a supremely consequential result. And it happened in a Senate that it was elected by a very, very small percentage of the population. Contrast that to 2020. We're in the middle of a global pandemic, and we had the highest turnout ever, really, in terms of sheer numbers. And certainly in the 120 years since people have been sort of keeping tabs on this, it was the highest percentage turnout. And the people who administer elections were courageous, and I don't do it. That's not my agency. I'm not taking credit for any of this. But people at the state and local level were courageous and creative and came up with all sorts of innovative ways. Basketball teams donated stadiums so we would have big spaces for people to gather that would be safer. Individuals donated money. Now there's been a little bit of a pushback on that, with some states saying we don't want any private money to help out, but America rose to the challenge in 2020 of conducting a very participatory election under extremely trying circumstances. And if we could do that, we could do anything. And we've also seen over the last couple of elections, big uptick in youth voting, and we really need them to turn out and to give us their energy and their creativity, because they are the future. So, let them take over.
A model of a concise, bright outlook for the future, Ellen. Thank you. Ian, Fernita, room to step up.
I can be really brief because I don't. I'm always, even when we have a positive congressional story, I always worry that Beyonce will come in and wreck it. But I do remember a conversation that me and Justin had a number of years ago. We were still kind of in a post-Shelby sadness, I was trying to convince Justin to make the leap to doing administrative law with me. I don't know if he remembers this, but I was like, why are we doing this election law thing, right? Like, let's just do administrative law. It's fun. They have interesting conversations. Don't talk to me about Chevron. I know it's a bad idea now. Yes. But at the time I was like, okay. And Justin said something that I never forgot. He said, remember, right? Quoting Dr. King, he said, the moral arc of the universe always bends towards justice. And he reminded me that we don't have any say over how long it takes for it to bend. Right? Like, all we know is that it bends, right? And so you can't jump ship just because it isn't bending as fast as you would like it to bend. So I guess my positive message is, even as we face tremendous obstacles, we have to still keep fighting, because it will eventually break our way. I don't know when, but the fight in and of itself is worth it.
So I'll just make one very quick point, which builds upon what Justin has said. The best time to be involved in American democracy is always tomorrow, right? So that sort of tells you of the progress that we have made, that we're fighting today, and that things are, when you think about the people who have been participating, that's not something that we would have seen. Fernita, you made this point 50 years ago, 100 years ago, 200 years ago, right? And so there's a resiliency, there's a broad participation. And I think, as to end and quote Jesse Jackson, we have to keep hope alive.
There is no better way to end than that. A profound thank you to you, Guy, and to you, Fernita, and to you, Ellen, for your wisdom and your leadership in all of the spheres in which you operate, and for this tremendously engaging discussion today. I think we're going to go back to Judith, I believe, to close us out, but I hope that this has been engaging for the rest of you watching, as I know it has been for me, and so I really appreciate the conversation.
Good afternoon. My name is Guy-Uriel. As Executive Director of AALS, I want to thank everybody who made today's powerful program possible. That starts with Mark Alexander, who envisioned it all and had the wherewithal to persuade the terrific moderators and panelists that joined us today. I want to thank those three moderators, the participants of the three panels, and of course, our crackerjack AALS staff. Our thanks also go to everyone who joined us today. Defending democracy is the theme not only for this program, but for this year for AALS and for the annual meeting that's being arranged by Mark Alexander for January 2024 in Washington, D.C. Sections have already submitted their programs for that annual meeting, but our great staff has reserved space in the program for what we call hot topics. And those topics don't have to be submitted to be part of the program until October 16th. There were so many great ideas tossed around today as part of the conversation. I put down just a few that will stay with me. Can law schools work together in protecting democratic norms? Can we model respectful discussions on difficult issues in our classrooms and our communities? Can we teach more about state and local government law and their constitutions, not just federal? So please, please, those of you who are here, panelists, moderators, all, do connect with colleagues, and not just at your law school, but with multiple law schools, please, and submit a hot topic proposal to be part of that program next January. If you missed any of today's panels, or you want to encourage a colleague to consider some of what was said, we will be posting a recording of today's entire program on our website. We at AALS look forward to working with you on the reforms and strategies, to quote one of our panelists, for these challenging times. Thank you. Let's make the most of today's ideas.